Hello and welcome to today's COVID-19 update and business brief. We'll be going over some of the new updates to COVID-related issues, sick leave, safety, and some other key points for you today. My name is Jamie Boswa. I'm a shareholder at Croloff, and my practice here focuses on employment law and business law. And I do a wide variety of employment related work for my clients, from policy development all the way through litigation and trials. And with me today is Paul Borges, one of the attorneys here at Croloff, who also practices in a variety of areas. And one of those that he works on frequently is employment law. So we are going to go over quite a few topics today, and but we can't provide specific legal advice for you in this format. And we need to know a lot more about your workplace and your particular employees in order to give legal advice. But what we're going to do here is just provide some educational information for you today, so that you can see what the issues are and where you can go to get additional information. So what we're going to cover is COVID-19 sick leave. Paul is going to kick us off with that topic. That bill was just passed and signed by the governor and enrolled on the 9th. Vaccine mandates and where we stand with that. What mask requirements are in place required for employers. What to do in terms of isolation and quarantine if you have an exposure in your workplace or someone tests positive. The additional leaves of absence that apply to your employees who might be out for a COVID-related reason, in addition to the sick leave. And then some basics on workplace safety and Cal OSHA rules that everyone still has to comply with as we are in 2022, still dealing with pandemic-related issues. We're going to pause at the end of each of these sections and take questions. You can put questions in the question and answer box or in the chat box. And additionally, if you would like a copy of the slides, please send me an email. You can reply to any of the e-blasts you got, or my email will be on the last slide and I can give you a PDF of that. So jumping right into COVID-19 sick leave, I'm going to hand it over to Paul.
Good afternoon, everyone. I'll be addressing the new COVID paid sick leave law that was passed by the governor and signed into law on February 9th. Let's see. Oh. Sorry, okay, there we go. The controls keep disappearing. Okay, so first we have here, this is going to be the new poster that the covered employers under the law are going to have to post in their place of business. And so we have a picture of the poster right here, and then below you'll see a link to where you can print out the poster and post it at your place of employment. Okay, so who is covered under this new law? This new paid sick leave law is going to cover all businesses with 26 or more employees, and all workers of those businesses, whether they're part-time, full-time, or temporary, are going to be covered. And additionally, the leave can be used for family members, which includes children, grandchildren, grandparents, parents, siblings, or spouses. The effective dates, the effective date is 10 days after the law was signed on February 9th. So the law becomes effective on February 19th. And it's retroactive and covers a leave that begins on January 1st, 2022, going through September 30th, 2022. As far as the reasons that employees can use the sick leave, so if the employee cannot work or telework because of COVID-19 related reasons for themselves or someone whom they care for, and the way this works, as far as the specific reasons for which the COVID-19 sick leave can be used, it's divided into two separate banks. So the first bank would be if you test positive for COVID-19 and if you're seeking a diagnosis for it. And under that bank, the employee would receive 40 hours of sick leave. But as far as the other reasons, for the sick leave. That's another bank in which the employee would receive 40 hours of leave. And that's when, if they're advised to self-quarantine or isolate by a healthcare provider or due to a federal, state, or local order or guidance, if they're attending a vaccine appointment, if they're experiencing vaccine-related side effects, or if the employee is caring for a child whose school or place of care is closed or unavailable due to COVID-19. So these banks are really, in more simple terms, it's divided between a positive COVID-19 test for yourself on the one hand, and then on the other hand would be other COVID-19 related reasons that aren't related to actually testing positive for COVID-19. And as you could see on the previous slide, since the leave is divided into two separate 40-hour banks for full-time employees, since they have those two 40-hour banks together, that means they can use up to the 80 hours of paid leave, of course, divided up as you saw on the previous slide. As far as the leave that's available for part-time employees, if they're on a regular schedule, they receive leave for the hours that they're normally scheduled for in 2 weeks. So for example, if that employee is scheduled regularly for 15 hours per week, then you just combine those 2 weeks together and they'd have 30 hours of leave. But as far as employees who have a varying schedule, it's a little bit more complicated, and you use a look-back formula that's based on the length of time they've been employed. So for employers, or for employees rather, who have been working for 6 months or more, you look at the average number of hours each day in the 6 months preceding the leave date. For employees who have worked from anywhere from 8 days up to 6 months, you would look at the average time worked over the full length of their employment. And if it's an employee who's only been working for a week or less, then you would just look at the total hours that they have worked. So for example, if they have worked on Monday, Tuesday, and Wednesday for 4 hours each day, then that would translate into 24 hours of leave. And there's some other limits that this law places on the amount of leave. So the time off for vaccines and boosters and related symptoms can be limited to 3 days or 24 hours, unless an employee receives a verification from a healthcare provider that they're continuing to experience symptoms past this period. And there's an offset for any leave provided in 2022 voluntarily by an employer. But employers cannot count paid sick leave under the California Healthy Workplaces and Healthy Family Act, also known as the 2021 COVID paid sick leave law. And if the employer paid a lower rate of pay, if they gave voluntary sick leave during 2022, then they must true up that pay and compensate the employee to bring the rate of pay up to what this new 2022 law requires. And I believe Jamie will be taking over the rate of pay section here.
All right. Thank you, Paul. So the regular rate of pay is what is required under this law, very similar to the California paid sick leave law that covers any type of illness. So that's technically referred to as the Healthy Families, Healthy Workplaces Act. So that is your 3 days or 24 hours minimum. A lot of employers do provide additional sick leave on top of that, but both of these laws require that sick leave be paid at the regular rate of pay. And you can pay at the regular rate of pay, or you can pay at a 90-day look back. And here down below, I have bullet points for that. It unfortunately doesn't line up perfectly with the other law. So you can't use the exact same formula if you're going to do the 90-day look back. But here, for the 90-day look back, you'd include total wages. You don't have to include overtime premiums. That's time and a half, just the regular time. And then you divide by total non-overtime hours worked in the full pay period. In the full, I'm going to start that again because I've gotten it all jumbled. So you'll divide by the total non-overtime hours worked in any full pay periods in the prior 90 days of employment. If you pay by the piece, commission, or some kind of other similar incentive-based, you would divide by all hours worked. So that's the 90-day look back formula. So if you want to do the 90-day look back formula, instead of paying the regular rate, you need to make sure you're doing that correctly. It doesn't line up perfectly with the existing California paid sick leave law. For employees who are exempt, you use the same method you use for other forms of paid leave. Usually this is taking the annual salary and dividing by the number of weeks worked. And there is also for all employees a $511 cap per day, very similar to what we saw last year. Now, if you have employees who earn above that, they can use some of your other paid leave, for example, vacation or any other type of paid sick leave that you provide to top up and reach their full amount of pay for time that they're off for COVID. But they would have to combine those two in order to reach the maximum, because the COVID sick leave law only requires that you pay a maximum of $511 per day. Now, I do want to mention that when we talk about the regular rate of pay, this is a very common issue that we see, and that includes all types of non-discretionary remuneration. So if an employee receives fixed bonuses, production pay, commissions, anything like that, those amounts are going to have to be included shift differentials, those amounts are going to have to be included in the regular rate. It's not just the flat rate of pay. So if this employee earns $15 per hour, but they also receive a weekly shift differential because they work the night shift, the regular rate of pay is going to be more than 15. It has to factor in that amount. If you have any questions or concerns about how to calculate the regular rate of pay or what should be included, that's a great question for an employment lawyer, because it is an area of high liability. We don't have time to go through that in today's presentation, which is focusing on COVID, but I want to make sure you're aware of that distinction, because even if you paid it the wrong way, you could still unfortunately have some liability. What documentation is required? So you can require your employees to submit proof of a positive test result under this new law. And that's because of the two different types of banks. They have to have a positive test result to qualify for the first bank of leave. And so you can require that. Second, you can require a second COVID test on the 5th day after the first test if the employer pays for the cost of the test. So there's a secondary testing requirement built in here in order to, I think, get a sense of how long someone should be out. And you're going to see why that is a little bit later in today's presentation when we get to the reasons for quarantine and isolation. They hinge on a 5th day test result. And then you have to list the COVID-19 supplemental sick leave that has been used on the pay stub. The idea with this was to reduce the calculations that employers had to perform to figure out how much was left. The prior law required you to put the balance remaining on the pay stub. This is only the amount used. And so it gives the employee some basis to see what you're counting against them, but you don't have to do that calculation for every employee, which I think most employers are going to appreciate. And then also I said near future because that poster went up this morning and I forgot to update this slide, but that mandatory poster that Paul discussed briefly needs to be provided to posted in your workplace at the physical location and then provided by email to any of your remote workers. The next section we're going to go into is vaccine mandates. So I'm just going to take a moment to go through the questions I have received and see if you have any additional questions about how to calculate, apply, and go through this new California sick leave law. Okay, the first question I had is about that second test. So yes, that's correct. You can request that second test, but you have to cover the cost. So the next question I have is, does this relate to only workplace exposure to COVID? Or if the employee was exposed, say, at a family event completely unrelated to work, does this still apply? This law does apply to every employee, regardless, so long as you have 26 or more employees in your business, regardless of the cause of the COVID or where they contracted it. It's just general across the board sick leave. The next question I have is there any reimbursement from the state? Currently, no. This obligation to pay this additional sick leave falls completely on the employer in California at this point in time. There has been some mention of reevaluating that if this law is extended, but thus far there is no reimbursement. So the question is, if the employee is out due to COVID, they are only allowed 1 week of pay. I'm just going to jump back to that slide real quick and we can look at the two banks. So if they, okay, so this is actually, I've made a mistake on this slide, so I have to correct this. So the COVID-19 symptoms and seeking a diagnosis falls under the other reasons. The positive test is actually just its own. So I wish I could correct it while we're in the presentation, but I got my bullet points off. So I was supposed to have just the one and then all of the others under the other. So if the employee has a positive test, that qualifies them for up to 40 hours of leave. For any of the other reasons, if they are caring for someone else, don't have a positive test results yet, but have a cough, but they're waiting for test results, those all fall under the other 40 hours. So what you're going to do is get proof of that positive COVID test result for the first 40-hour bank, and for the other reasons, you're going to put it under the second leave bank. So they have 40 hours for each. So if they never test positive, for example, if they're only caring for a family member who's sick and this leave expires, then yes, they would only have become eligible for one of the 40-hour leave banks. If you send your employee to a free test, does that count as covering the cost, is the next question. The answer to that is potentially. So you would have to cover any out-of-pocket costs that that employee has to pay for. Right now, tests are free, so no. But do be careful that if you're requiring the employee to do something like go down to a testing center when it's not their regular paid hours, you may have to pay for that time as time worked. So that could be time that they seek compensation for in terms of hourly pay. Do we owe pay for an employee who is no longer with us since this is retroactive? I don't know the answer to that question. I hadn't thought of that. That is a good question. They would have to reach out to you, I suppose, and to confirm that it was a COVID-related reason and potentially provide that documentation. If you want to shoot me an email, I will look into this and get back to you on that question, because I'm not sure that the law addresses it. Paul, do you recall specifically the language of the law if it applies to former employees?
I never saw anything about that, just that it applied to all employees. I guess that it kind of infers that it means current employees, but I'm not sure.
Yeah, I might be silent on that, which is maybe why I don't know the answer. But let me give a little bit more thought to that. If you shoot me an email, we can have a further discussion on it. Okay, this question is about vaccine mandates. Does vaccine mandate time off apply to employers with less than 26 employees? For vaccines, that's different. Yes, the sick leave pay. So we have multiple competing and overlapping obligations to pay employees for COVID-related reasons. So this particular COVID-19 sick leave pay applies only to employers with 26 or more workers. However, if you are mandating vaccines for your employees, there may be an obligation to provide hourly compensation for that. even if you don't qualify for sick leave. And we'll get to that a little bit more in the vaccine section. Ask another question if it's still not clear. Oh, yeah, this is another question from an attendee about a former employee who wants to be paid. Of course, the safest thing to do would be to pay it, but if you'd like to talk with me a little bit more about that, go ahead and shoot me an email and I'll follow up with you. If an employee has COVID-19 symptoms and is out of work, but they test negative, are they ineligible for this bank of hours? The answer would be yes, they are ineligible because the COVID-19 sick leave is going to cover the time where they're experiencing symptoms, but still waiting for a test result. So if they test negative, the presumption can be that they have some other kind of virus or illness or that is making them sick. So you could apply your regular sick leave to that illness. But if your pay period is coming to an end, they don't have the test result out, they're still out, then you would have to make that decision at that point in time, potentially. So there are potential overlaps and confusion relating to which COVID sick leave you could apply, and you can ask the employee to make that decision. Do you want me to apply the COVID-19 sick leave, or do you want me to apply regular sick leave to this leave? They do have that option. All of you have the former employee question, and I hadn't thought of that one. If an employee calls in with a positive COVID at-home test and sends a picture, is that valid? So we have some guidance from other COVID leaves that indicate that for the employee to have verified a negative test to return to work under the emergency temporary standards, for example, they should have a monitored test or take the test in front of the employer. That's to ensure that people aren't coming back to work in order to continue getting paid because paid leave had lapsed. And they were falsifying test results. So I would recommend following that procedure across the board. I think that makes it simpler. If that's technically required, we don't yet know because this law has not yet been tested. We don't yet have the guidance out from the DLSC on it. More guidance will be issued answering some of these frequently asked questions. But at this very early stage, the day before it goes into effect, I think that across the board, if the more consistent you are, the easier it is going to be for your employees to understand. But do keep up with that guidance. Check back on the DLSE and DIR websites, the Department of Industrial Relations and the Department of Labor Standards Enforcement. The link is there with that poster Paul put up to see if that is clarified as time goes on. I have another question on this issue of if they have COVID symptoms and are waiting for a COVID test, do they get COVID sick leave until they get their results? The answer under this law, I think, is yes. They can apply the COVID-19 sick leave if they have COVID symptoms and are seeking a diagnosis, meaning waiting to get a test or waiting for test results. Can the employee submit a home test to validate the positive test? I would caution with home tests that they are a little bit less reliable than the PCR tests. And there are aspects of other portions of California law that require some kind of verification that that employee is the one that actually did that test. So there are tests that can be done online where you log in and some health provider watches you do the test. Some people that have traveled may have experienced that. Those are allowed under some of the standards we have. You can also have the employee do the test while you watch, either through a Zoom or come into the office and do the test. If you're not concerned about exposure, maybe they're vaccinated, for example. We're going to get more into isolation and quarantine here later, but you would want some way, I think, to verify. And we are going to see if the state issues more guidance on this, because sometimes they do something that I thought was didn't make sense. So they might say, yes, a home test is sufficient. So we're going to keep on top of that guidance and continue watching what the Labor Commissioner and the Department of Industrial Relations releases on that, since we don't have a clear answer under this law. Okay, in the chat, I have more questions. Are in-laws included? Under COVID-19 sick leave, the answer is no. Under other California laws providing for leave, yes, but under this one, no. Is the first bank for only a positive test? The answer is yes. You have to have a positive test to qualify for that first 40 hours for you or a family member that you're caring for. If they are out of work, but the test is negative, yeah, then they are not eligible for that first bank. They fall under the second if they're waiting for a test. Does the law apply to employers with 26 employees or more? Yes. So this new sick leave law that we're talking about right now at this point of the presentation applies only to 26 or more. The rest of you, we're going to go through those a little bit later, but the standard laws that are in place in California for any type of illness related leave are what you would be applying. This does not, I have another question. I understood that this did not replace the current replacement pay for work-related COVID. Did that change? So if you have employees working in a city that provides local COVID-19 sick pay, you can offset that. That's what Paul was discussing on that slide, is that you can subtract that. Or if you voluntarily provided COVID sick leave for your employees, say at minimum wage, and you weren't required to under any local ordinance, then you do need to true up to make sure that you paid at the rate the law now requires. If you were paying less than it requires, but you can offset that. So if an employee already took 80 hours of leave under a local law, for example, you don't need to provide more. So this doesn't offset a COVID leave, but it does offset against a COVID leave. It does not offset against ordinary sick leave. So if someone was out because they had a digestive illness that was not related to COVID, they get COVID-19 sick leave on top of that. But they do not, it doesn't take the place of other COVID related leave laws except for local ordinances or voluntary leaves. If an employee has symptoms but tests negative, when we go back to the fundamentals of this law, we see the two leave banks. So you're going to say, do they have a positive COVID-19 test? No. So now we're looking at the second leave bank. Do they meet any of those criteria? We have experiencing symptoms and awaiting a diagnosis. So during that period of time, yes, this law potentially then does apply. And so they just need to self-report to you that they're experiencing COVID symptoms and that they're seeking a diagnosis, which could mean they're waiting for a doctor appointment, they're waiting a test, or they're waiting a test result. As soon as they have a negative test, then this law no longer applies to them. The law is not clear on what you do. Do I have to go retroactively back and take that away from them? Law is not clear on that. But as soon as you have a negative test, any leave going forward, I think definitely when you look at the two leave banks, you're going to say, did they test positive for COVID? No, we throw that one out. Are they still awaiting a diagnosis? At that point, no. So then that would lapse them into ordinary sick leave, or if they're out of sick leave, vacation, or any other type of leave that applies. And we're going to go through those. Employers are not reimbursed for this leave currently under the law. Can you ask for a positive test result proof if it's a family member? The answer is yes. What if they are experiencing symptoms and refuse to test? They might not qualify under this law. If you have an employee that is refusing to test or is having some objection to that based on a religious exemption, that's the kind of more complicated situation that I would recommend reaching out to counsel and discussing more individually. If an employee was paid regular sick leave for COVID-19 illness and now wants to use this sick time. Do employers have to reimburse their regular sick bank hours? Yes, that would be how it would work. You would go back and reallocate the COVID-19 sick leave to that absence, which would then reimburse their regular sick leave balance. Okay, I think I've run through all the questions on COVID-19 sick leave. So we're going to move into the next category of this presentation. Some of these questions will probably come up again, which is fine. Keep asking them. And we're going to move on now to vaccine mandates. Were you doing vaccine mandates, Paul, or was that me?
That was you.
Okay, sorry, I've forgotten. Okay, so current vaccine mandates apply to healthcare workers, school employees, state employees, workers at high-risk congregate settings, adult and senior care settings, direct services being provided to elderly or disabled individuals, schools, school children, and private employers with 100+ employees, which actually was stayed by the court and then overturned. So that is no longer pending. I mean, they keep throwing it around on a federal level, so we'll see what happens, but it is not currently in effect. There is a proposed mandate that I think you'll all be interested in. It was a bill that was passed in this current legislative session. They're getting right back to work, which would require vaccines for all workplaces and all employees. New hires would have to have had at least one dose by their start date and a second dose within 45 days. It would allow for medical or religious exemptions, and it's scheduled to go through committee hearings this spring. And then they're also considering another bill that would address customers entering into a business. So this is really far reaching. So we'll follow this and see what happens. Of course, if it's passed, we'll do another update for you, another webinar. But we haven't seen the end of vaccine mandates in California. So for healthcare workers, I just always like to include this. If you've attended prior webinars, you've seen it, but this is the list of facilities that fall under the mandate for healthcare workers, in case you are curious about that. And then who is a healthcare worker? And this applies to other vaccine mandates as well. And some of them don't just include your paid employees, but could also include students, interns, trainees, volunteers. So if you fall under one of the vaccine mandates, what you're going to want to do is check that mandate and see how expansive it is. Do your volunteers need to be covered? Do your janitorial workers who come into patient spaces need to be covered, etc.? So just to make sure you're covering all of your workers who are mandated to be vaccinated, because worker has a pretty broad definition under some of these mandates. There are exceptions for, and I'm doing healthcare workers because it's been in place the longest, but this applies also to the other categories of mandates as well. Some of them are slightly different, but very similar. So those with a religious belief that prevents vaccinations, or those with a medical reason to not be vaccinated, have to provide a declination form. And then there has to be a written statement from a physician, nurse practitioner, or other licensed professional working under a physician for a qualified medical reason. And they have to state the reason that the employee, or they have to state that the employee cannot receive the vaccine for a medical reason, and then the probable duration of that. So if this is a short-term health condition where they're recommended, during a course of treatment or medication, not to receive it for the next month, but then they're eligible after that, that's what that would have to be provided. And so if you need forms to provide your employees for the exemptions, that's something that we provide to our clients that you can probably also receive from your employment law attorney. So under the healthcare worker law and some of the others as well, there are a set of expectations required for those who fall under the religious or medical exemption. They have to be tested twice weekly in an acute healthcare setting or once weekly in other healthcare settings. The other mandates are typically once per week. And then the workers have to wear a mask. I just want to touch briefly as we move more into these mandates and as California continues to impose more of them. What is a religious belief? What qualifies for that exemption if you're dealing with these in your workplace? It doesn't have to be an express tenet of the religion that vaccine is prohibited, but it has to have a religious foundation. It can't just be a healthy living lifestyle. It really does have to be a legitimately held religious belief. But it doesn't have to be a traditional religious belief. It could be a belief in a God or any kind of supreme being is not required. For example, Buddhism qualifies even though there is not a supreme being. It has to address fundamental and ultimate questions. These are from case law, of course, these complicated definitions. And it can't just be one isolated teaching about vaccines following one particular health provider or speaker on that. It has to be a belief system. So when providing your forms to your employees to designate that they have a religious exemption, I do recommend some questions that go through some of these elements so that you have good documentation about that you've done your due diligence in obtaining information that this is a legitimate religious belief, and then have the employees sign that and turn that in. I have employers that range on a spectrum of how strict they are with this versus how lenient, but you do want to have that documentation for your file, regardless of how strictly you want to enforce this. Okay, that's it for the vaccine mandates that we were going to go through today in terms of the exceptions, the categories that they apply to, and kind of the concepts surrounding religious belief exemptions. Do you have any questions on that category? No. Okay, we're going to move on to the current state of mask mandates, and Paul is going to handle this one for us.
Okay. So despite what everyone's aware of earlier this week with the statewide mask mandate ending, there's still settings where masks are required for everybody. And that would be in the setting of public transit, in healthcare settings, which would also include long-term care facilities, adult and senior care facilities, indoors in K through 12 schools, child care facilities, and other youth settings, state and local correctional facilities and detention centers, and homeless shelters, emergency shelters, and cooling shelters. And you can see more information on that on the link below. Masks are required for unvaccinated persons, but merely recommended for all other persons in the following settings. And this would be in retail, such as shopping malls, in restaurants, movie theaters, family entertainment centers, in meetings, and in state and local government offices that serve the public. And this current slide is the exceptions to the ETS requirement of masks for unvaccinated workers. As you can see, employers must require unvaccinated employees to wear masks indoors with the following exceptions. And so that's for work locations where there is only one employee who does not have contact with other people, employees who are just working from home, employees who are covered by the aerosol transmissible disease regulation, and employees working from a location chosen by the employee, which is not under the control of the employer. For instance, this would be an employee teleworking from a cafe or a friend's home. You'll see in the next paragraph there that unvaccinated workers must be provided respirators. And what that means is that they must be provided with N95 masks, not just the the cloth masks or the simple surgical face mask. And all the information here is available at the link below, which I believe is the OSHA website. And then for further information, the Stockton Chamber of Commerce has the necessary PPE to distribute. So if you're in need of PPE for any of your workers, I would get in contact with the Stockton Chamber of Commerce because they can distribute that gear to you. And there's some more exceptions to the mask requirements, and that would be children who are under 2 years old, because this would cause a risk of suffocation. People with medical conditions, mental health conditions, or disabilities that prevent wearing a mask, which includes those who cannot remove a mask without assistance. People who are hearing impaired or communicating with someone who is hearing impaired, and seeing the mouth is essential to them for communication. And people for whom wearing a mask would create a risk to the person related to their work. And as far as in the settings where the masks are still required, the following is more guidance for businesses that's posted on the OSHA website. And the following bullet point list you see here kind of goes from the least restrictive regulations to the most restrictive regulations. So as you can see here, in these businesses or settings where masks are still required, the operator of the business may choose to provide information to all patrons, guests, and attendees regarding the vaccination requirements and allow individuals to self-attest that they're fully vaccinated, which basically means you ask them if they're vaccinated, and they confirm that they are. Next, they can implement vaccine verification to determine whether individuals are required to wear a mask. And lastly, which would be obviously the most restrictive means out of the three, would be to require all patrons to wear a mask. And then obviously no person can be prevented from wearing a mask as a condition of participation in activity or entry into a business. So if someone's at your place of business and they want to wear a mask, yeah, that's their right. They can't be told not to do that. And next we have isolation and quarantine. So I'll hand it off back to Jamie.
Okay, so some of these timing issues that you saw in the last slide, the 5 days and things like that, these are coming out of the isolation and quarantine requirements, and they line up with these. So isolation is the procedures that you have to follow for an employee who tests positive for COVID. So if the employee tests positive for COVID, they have to be excluded from the workplace for at least 5 days. On day 5, if they aren't experiencing symptoms or their symptoms are improving and they test negative, they can come back to work. If the employee does not test, maybe they're one of these employees that refuses to, but they don't have symptoms, they can return only after day 10. If the employee has a fever, they can't return until their fever resolves. And if an employee has ongoing symptoms that are not resolving, they cannot return until day 10. So on day 7, if they're still experiencing the bulk of their symptoms, things aren't really clearing up, they need to continue to be excluded from the workplace. So when I say this applies to all employees, this is both vaccinated and unvaccinated employees, or those who are experiencing symptoms or not experiencing symptoms who test positive. So anyone in your workplace who has a positive test result, this is the procedure to follow for them at this point in time. So also one thing to note, even if your employee is vaccinated, if they have tested positive, they need to wear a mask for 10 days. So we were talking about only unvaccinated employees are required to wear masks at this point under the Cal OSHA standards. The employees who test positive need to wear a mask until 10 days have passed since their positive test result or their first symptoms. And then I wanted to go back to this slide here on masks. So this covid19.ca.gov, that link at the bottom, they keep that very updated. So if you aren't familiar with that website right now, that is providing a lot of the updates and easy to read format. We lifted this right off that website. This is a screenshot To answer any questions that you might have about statewide requirements. Currently, San Joaquin County does not have any additional restrictive requirements. So you can go to the state website and feel confident that you're following the most up-to-date guidance. If you have employees working in other cities, large cities, Sacramento, San Francisco, Alameda, some of the other Bay Area cities, Los Angeles, San Diego, there are additional requirements. So you're going to want to check those. But from a statewide perspective and in San Joaquin County specifically, the state website is updated. So that's isolation. So your employees who have tested positive. Now we're going to quarantine. This is employees who were exposed to someone who tested positive. So unvaccinated employees or employees who are eligible for a booster but have not yet received it, they have to be excluded for at least 5 days after a close contact. We'll go through what a close contact is in a moment. They have to test on day 5. They can return to the workplace after day 5 if they don't have symptoms and they test negative. If they do not test, but they don't have symptoms, they can return after day 10. They must wear a face covering for 10 days if they were exposed, even if they don't have to be excluded. If they test positive, you revert back to isolation. So as soon as your employee tests positive, you're going to follow the isolation protocols. If they develop symptoms, they have to be excluded from the workplace pending the results of their test. So this is the quarantine requirement. So what you're going to want to do is if you have someone who tests positive, you're going to figure out who had a close contact with them and then require the quarantine rules for those people. Employees, so this is for unvaccinated or booster eligible. Employees who have received their booster or were vaccinated, but it hasn't been enough time for a booster to be necessary, they do not need to quarantine. As long as they test negative on day 5, they wear a face covering for 10 days after the exposure, and they don't test positive. If they do develop symptoms, they have to be excluded pending the result of a test. So you have a lot more freedom to keep employees in the workplace once they have been vaccinated and received their booster, fully vaccinated and then boosted if eligible. So we have multiple tiers for exposure. If you test positive, it doesn't matter what your vaccination status is. Close contact is going to be someone that was within 6 feet of a COVID positive employee for 15 minutes collectively over a 24-hour period. And they came into contact with them in the 48-hour period before they developed symptoms or before they tested positive if they don't have symptoms. So Paul comes to work next Wednesday. He has a cough. We send him home. He shouldn't have come to work if he had a cough, but nonetheless he did. So he comes to work, he has a cough. He goes home sick. The following day gets a test result that he was positive. What we're going to do is we're going to look back and say, okay, Paul was in the office. Paul developed symptoms on Wednesday. So Paul was within the infectious period on Monday and Tuesday. Was Paul within 6 feet of anyone for a collective 15 minutes or more? Well, he passed Brian in the hall, but that was only for 2 minutes. So no. But he did have 2 meetings with Courtney that were each 10 minutes long. So she is a close contact if those meetings occurred on Monday, Tuesday, or Wednesday. So hopefully that makes sense. Okay, so that is it for the isolation and quarantine procedures. My recommendation to you is if you have questions to call counsel, of course, but to just work through it in a step-by-step fashion. So is my employee positive? Yes. Okay, what are those rules? Is my employee exposed? Okay, yes, let's talk about that. Go through them in a systematic way. If you go to this website that I have at the bottom, they have a nice little chart to walk you through these items. Okay, I have a question here. If an employee refuses to test after exposure or being sick, what options do we have to enforce testing? Can we write up the employee? The answer is that it depends. So we need to look at why is the employee refusing to test? Is there a religious objection? Is there a medical reason not to test? I've never seen that, but perhaps. Is there some other reason they are not testing? If you're requiring them to test, you need to pay for that time and pay for any out-of-pocket costs they experience because of the test. And then if your COVID-19 policy allows for all of the exceptions that will be required in the law for some kind of exemption, and the way you've decided to keep your business safe is to require testing, then that could potentially lead to a write-up or to a termination. But before doing write-ups and terminations, this is a very complicated area of the law because we have so many overlapping protections. We have employees who may not have access to testing. We have employees who may have religious objections to testing. We have employees who have disabilities. We have all sorts of different things that could be contributing that could fall into a protected category. So before disciplining or writing up for COVID policy violations, you really want to make sure that those policies dot all the I's and cross all the T's for all of the different laws that may fall under them. Okay, I'm going to move into leaves of absence here. So these are leaves of absence in addition to the sick leave we just went over. So if sick leave applies, yes, and all of these apply if you have 26 or more. But if you do not have 26 or more workers, then these are the ones that are going to apply to you. So non-COVID related leave laws. California's paid sick leave, the 3 days or 24 hours that passed in, I guess, several years now, 2018 or 2019, that could potentially cover your employees, and they have the option to use that for a COVID related reason. Including prevention, including the fact that their child is not able to go to school, or that they are wanting to seek a test because they have some symptoms, something like that. Workers' compensation leave applies. If your employee was exposed in the workplace and developed severe enough symptoms that they are out due to illness, workers' compensation could apply. And provide some pay as well. The California Family Rights Act now applies to any employer with 5 or more employees. It's an unpaid leave. It's just job protection. You have to hold the job while they're out on this leave, but it provides up to 12 weeks of leave. Now, this could apply in addition to a paid sick leave if you have someone that becomes severely ill with COVID, or you have someone who has a health condition that's exacerbated by COVID. For example, a diabetic employee or an employee with another complicated health condition who can't return to work because that condition got worse because they had COVID. The Family and Medical Leave Act overlaps in some circumstances with the California Family Rights Act. It applies to those of you who have 50 or more employees. That's the federal version of the law. The disability and accommodation leave under the ADA and the Fair Employment and Housing Act. So these require that you accommodate a disability of an employee if it's not an undue burden on the workplace. So this applies in situations where you have leave that's maybe longer than the 12 weeks that's needed, or someone needs to work from home, or there's some other accommodation that could apply in the workplace. You need to always at the end of a leave assess, does this apply? Is there a need for engaging in the interactive process? Do I need to accommodate this employee? So if you have an employee that's out on a very long leave, or they're running through the different types of leave, first COVID paid sick leave, then regular sick leave, then California Family Rights Act, that's a situation that's more complex, leads to more liability exposure, and that I do recommend contacting your attorney. Those non-COVID-19 leave laws provide for time off, but not necessarily pay. The wage replacement is provided by this shorter list. Any exclusion pay under Cal OSHA, if someone is exposed and you've asked them to remain out of work. State disability benefits could apply if someone qualifies and their doctor will certify that they are disabled. They can receive pay for that, even for COVID or any other illness as well, but COVID does qualify there. Paid sick leave is, of course, under either COVID or non-COVID sick leave, going to provide for a wage replacement. And then, like I mentioned earlier, if it was a work-related exposure, there may be workers' comp benefits that could provide some pay for your employee who is out of work. Just briefly, the California Family Rights Act, this went into effect for those with 5 or more last year, but just a refresher here for you. Family members here does include siblings, grandparents, grandchildren, domestic partners, and parent-in-law. So that time off may cover an employee who is caring for a parent-in-law with COVID sick leave, but the COVID sick leave pay might not apply. So unfortunately, they don't all line up. And so you have to evaluate under each of these different categories whether or not someone is going to qualify and whether it applies to them, and give them the appropriate notice of that. So it is a difficult area to track and follow all of these leave laws we have in California. So that is one area in which you may want to seek out assistance of an employment lawyer. Also, just a friendly reminder, California has school and childcare leave. So if you have 25 or more employees, you have to provide up to 40 hours of leave, unpaid, but they can apply other benefits that you may offer to that, like vacation or PTO. And then an employer can choose to use this or choose to use paid sick leave to cover their child's absence as a preventative care. So this may apply if other leave is exhausted. It may apply if your employee doesn't qualify for the other leave for some reason. So this is just something to keep in mind and make sure you're providing if it applies to your workers and your employees. And a school closure does include a school going 100% remote or requiring your child to do remote learning because they can't go to the school facility. Okay, that's the end of that section. Do we have any questions, any additional questions about any kind of California leave that may apply to your workers? Okay, I don't see any. So I'm going to jump forward here to workplace safety. Paul is going to cover this. We are running short on time, so we're going to go through this pretty quickly, but the slides are available for you and you can always ask us follow-up questions. We'll stay and answer any questions that you have after the presentation ends.
Okay. So since COVID is still considered a workplace hazard, you do have to have protocols in place. And one of those is the Injury and Illness Prevention Program. And here we have a link to the OSHA site, which can give you guidance on how to set up your protocols. And then also has a template, which you'll see on the next slide, for the Injury and Illness Prevention Program. So here's a picture of the model template right here for how to set up those protocols. And then there's, again, a link at the bottom that can take you to that template. And then this is also something that myself or Jamie could help you with. Just email us if you have any questions or need guidance in this area. So the required elements for a COVID-19 prevention plan: you have to have a system for communicating with employees, identification, evaluation, and correction of COVID-19 hazards, have face coverings where necessary, have engineering and administrative controls to reduce transmission, procedures for investigation and response to cases, training and instruction for employees, testing for unvaccinated symptomatic employees, exclusion of COVID-19 cases and exposed employees, and maintenance of records of cases of reporting requirements. And the ETS, the emergency temporary standards, are still in place. However, these are the exceptions to them. All employers are covered except for workplaces with only one employee who has no contact with any other people, employees who are working from home, employees who are covered by the aerosol transmissible diseases regulation, and employees who are working from a location chosen by the employee, which is not under control of the employer. For instance, if you're teleworking from a cafe or the home of a friend. And as far as the ETS requirements, in response to outbreaks and infections, an outbreak is defined as 3 or more cases in a 14-day period, and a major outbreak is defined as 20 or more cases within a 30-day period. So in response, you must offer testing to employees at no cost during working hours if exposed to the workplace, and you must provide with required disclosures. Then you have to report to the health departments as required for outbreaks, maintain a record of all COVID-19 cases, and report serious injury or death to Cal OSHA immediately. As far as reporting serious illness or serious death of an employee that occurred at work or in connection with work within 8 hours, you must report inpatient hospitalization if the employee became sick at work, or if the employee became sick at home, but the illness was work-related. And as far as work-related reporting requirements, you have to report multiple cases that arise in the workplace, the type, the extent, and the duration of the contact that the person who tested positive had with others, or the people who tested positive. There needs to be physical distancing and controls in the workplace, and you must contact anyone with whom you had COVID, or contact with anyone with COVID-19 or symptoms of COVID-19. So it's smart to report even if COVID-19 is not yet diagnosed. The recording requirements for high hazard employers. You must record in log 300 if applicable to your business, and illness resulted in either death, days away from work, restricted work, or transfer to another job, medical treatment beyond first aid, loss of consciousness, significant injury or illness diagnosed by a healthcare professional. And this should be confirmed before it is recorded. And again, there's a link to the OSHA website right there if you would like to have more information on the reporting requirements for a high hazard employer. As far as workers' compensation reporting, all positive COVID-19 results must be reported regardless of whether the employee contracted the virus from work or outside of the workplace. It must be reported within 3 days. And as far as the details of what must be reported, you have to report the date of the positive test, the address of the place of employment during the prior 14 days, and the highest number of employees who reported to the place of employment in the prior 45 days. As far as the notice that must be provided to employees, you need a written notice to all employees, subcontractors, independent contractors who are at the work site within the infectious period who may have been exposed to COVID-19. There needs to be written notice regarding COVID-19 related benefits that employees may receive, which would include workers' compensation, COVID leave, paid sick leave, and the company's anti-discrimination, anti-harassment, and anti-retaliation policies. And then we wanted to note here that you will want to update your notice policies as this new COVID sick leave law that came out within the past week, because there are new changes within that law. And lastly, you must give notice of the company's disinfection protocols and safety plan to eliminate any further exposures per the CDC guidelines.
Okay, we've reached the end and only a little bit over, so we did okay. Are there any other questions that you would like to ask? Go ahead and put them in the Q&A or the chat. If you would like a copy of the slides from today's presentation, please send me an email. My email address is there on the screen, and I will get you a copy of those. I have one question. If we have the ATD policy, we do not need to follow the ETS. If your business is covered by the ATD standard, the aerosol transmissible disease standard, that is very long and comprehensive. And so there's an exemption from the emergency temporary standard for you. So no, you just need to comply with the aerosol transmissible disease standard. Now, some of the Notices of exposure and other things like that are part of the emergency temporary standard, but they're also have been incorporated into other laws. So those notice requirements, you will need to comply with those. But the masking requirements, et cetera, those are all subsumed within the ATD standard if your business has to comply with that. Any other questions? Okay, great. Hopefully we answered most of them as we went through. Feel free to reach out to us if you have any questions later on pertaining to this presentation. Good luck to everyone. Thank you for joining us, and we hope that you found today's presentation helpful. Thank you.
Thank you, everyone.